Hello everyone and welcome to Uncivil Law. For today's case, we have the story of Edith McCurry and Kenco Logistics. This is a story of an appeal gone wrong. The Court of Appeals is beating the attorney who filed the appeal to death because they filed a frivolous complaint and one that was badly formatted to boot. So we're going to watch the Court of Appeals slowly torture the attorney and then order him to show cause why he shouldn't be disciplined. So this is basically an attorney's nightmare gone to full wrongness. This is the kind of thing that, we have bad dreams about. So let's read this and see what happened. Edith McCurry worked at an Illinois warehouse owned by Mars, the well-known candy maker. In March, Kenco lost its contract with Mars and laid off employees, including McCurry. More than a year later, she filed two rambling, of course they are, pro se complaints accusing Kenco, Mars, and several of her supervisors of discriminating against her based on race, sex, age, and disability. She also alleged that Kenco and Mars conspired to violate her civil rights. The district court consolidated the suits and dismissed some of the claims. The defendant then moved for summary judgment on the rest. It's slightly impressive a pro se was able to get some of their claims to a summary judgment, so I guess there was some evidence there after all. Okay, not bad. The defendants moved for summary judgment on the rest. McCurry's response violated local summary judgment rules, so the judge accepted the defendants' factual submissions as admitted and entered judgment in their favor. McCurry retained counsel and appealed. McCurry doesn't challenge the judge's decision to enforce the local summary judgment rule. As a result, and unsurprisingly, the uncontested record contains no evidence to support a viable discrimination or a conspiracy claim. Indeed, the appeal is utterly frivolous, and McCurry's monstrosity of an appeal brief is incoherent, so we also order her lawyer, Jordan Hoffman, to show cause why he should not be sanctioned or otherwise disciplined. Wow, that's a lot. So for those of you who are wondering what's going on, there's a local rule, and I'm sure we're going to cover this substantively in a minute, but there's a local rule that basically says if you don't respond to things in a particular way, it's taken as admitted. So here, the pro se did not respond in the way that the rules required, and so everything the other party said was taken as true because they failed to respond. It was taken as admitted. So because everything the opposing party said is taken as true, she obviously lost her case. Because that is factually now the record, her basis for appeal is non-existent. The facts are not favorable to her because they've been taken against her. So she had no basis to appeal. She appealed anyway. A lawyer took her case. It was frivolous. Bad things are now occurring. If anyone ever gives me an order to show cause, I'm going to crap myself. I'm just going to plead mercy, I think, is what I'm going to do. I'm sorry, whatever it is. I'm sorry. Please show mercy on me. I think it's basically going to crawl into a fetal position, I think is my legal tactic if that ever happens. Because, yeah, fetal position sounds about right. Yep. Wow. We begin with the judge's decision to enforce the local rule. McCurry violated multiple provisions of the rule. Under the rule, a response to a summary judgment motion must include the following: specific sections with appropriate headings, an introduction, a response to the moving party's statement of undisputed material facts, and an argument section. McCurry's response to the defendant motion contains none of those sections and was instead a disorganized, rambling, and hard to decipher mess. Local rule requires the response to be in separate subsections: undisputed material facts, disputed material facts, the disputed immaterial facts, the undisputed material facts, and any additional facts. I'm not quite sure, because I don't practice in this circuit, I'm not quite sure why you would list immaterial facts, either disputed or not. If they're immaterial, then you don't care. So why would you list them? I'm a little slightly confused. I'm probably missing something because I don't practice in this circuit. I guarantee you if I ever filed that and I found this rule, I would talk to attorneys who knew the thing and ask, what am I supposed to do here? Because maybe it's better on an explanation. I'm not sure why I would on surface. So I'd ask someone with experience, why would I do this? And they'd explain it to me, I'm sure. And I'd be like, oh, okay. And then I'd do it. Good attorney. McCurry's response was woefully non-compliant. Although McCurry did not include an argument section in her brief, her arguments were scattered randomly through a 62-page response. The local rule limits argument sections of a response brief to 15 pages or 700 words. Incidentally, I am in favor of page limits. It really helps to sharpen the legal reasoning and prevents everyone from going off board. And everyone, including your client, sometimes likes you to say more than you can. So I'm personally a fan of a rule that constricts my writing because it makes it much easier to justify why it's constricted. It makes my arguments much better than they would be otherwise. And also makes it much easier to respond to the opposing side. So anything that puts in a reasonable page limit, I'm a fan of. So I support this rule. Under the local rule, the failure to properly respond to a numbered fact in an opponent statement of fact will be deemed an admission of that fact. So just to be clear, what happens here is that the opponent gives a statement of facts with numbers in between. If you don't dispute it, it's taken as admitted. This is the local rule. So you have to be on notice of the rules, and if you don't do this, it will be taken against you. Okay. We have repeatedly held that district judges may strictly enforce local summary judgment rules, and the judge did so reasonably here. In August 2016, McCurry filed a 77-page, 386-paragraph pro se complaint based on race, age, gender, and disability. Not 2 weeks later, she filed a second lawsuit against largely the same group of defendants. This one was sprawling, at 89 pages and 423 paragraphs. That is longer than anything I've ever written, by quite some margin. So she needs to learn how to constrict herself much better. The judge dismissed some claims but allowed the following to proceed. Claims against Kenco for discrimination on the basis of race and sex. A claim against Kenco, Mars, and supervisors for discrimination on the basis of race in violation of 42 U.S.C. 1981. A claim of Kenco for violation of age discrimination. A claim against Kenco for a violation of the Americans with Disability Act. And conspiracy. The defendants moved for summary judgment. McCurry's response did not comply with the local rules, so they're taken as admitted. Charitably working his way through each claim, the judge concluded the evidence was insufficient to support liability in the form of employment discrimination. With that predicate out of the way, the court now gets into the beating up on the attorney section of this case. This appeal represents a shameful waste of judicial resources. We take this opportunity to reiterate that district judges may require strict compliance with local summary judgment rules. Can a pro se attorney seek relief pursuant to 60B for ineffective counsel? Well, probably not, because, this is why it's generally not a good idea to represent yourself, all things being equal, because, yeah. And the fact the judge strictly held this rule against a pro se means the judge was really irritated. Because normally judges give slack to pro ses. They show mercy. And they strictly held the rule against the pro se. So the judge must have been super salty. So I can only begin to imagine what was in some of this complaint. So another good reason to get someone to represent you. The purpose of an appeal is to evaluate the reasoning and result of the district court. Non-compliance with appellate rules wastes time and resources and frustrates the review process. Sanctions are appropriate where rules are violated, especially when their violations are multiple and flagrant as they are here. Evil Coleslaw says, don't they tell you as part of agreeing to let yourself be pro se that you can't appeal? They give you warnings in criminal cases, not civil cases. So if you file civilly, you're just totally on your own. They're not going to give you any warnings because obviously the due process issues are much less significant in a civil case than a criminal case. So they're just going to destroy you. If you're doing a criminal case, they'll warn you first. I shouldn't be genius to recognize that if you're filing things before a court, that's an issue where you're going to want to be pretty solid. So I'm filing things in a court should crystallize your attention. And the fact that didn't happen is somewhat disturbing, but yeah. Rule 38 of federal procedure permits us to impose sanctions if an appeal is frivolous. If a court of appeal determines that an appeal is frivolous, it may, after a separately filed motion or notice from the court and a reasonable opportunity to respond, award just damages and single or double costs to the appellee. McCurry's appeal rests on factual assertions that were excluded from consideration below because Ms. Curry disregards several procedures in the local summary judgment rule. Her appeal arguments are insubstantial to the point of incoherence and has no chance of prevailing in court. An incoherent pro se. Well, news at 11, right? The patently frivolous nature of this appeal isn't the only thing that troubles us. The hopelessness of McCurry's cause didn't deter her lawyer, Jordan Hoffman, from signing and submitting a bizarre appellate brief laden with assertions that have no basis in the record and arguments that have no basis in law. It is chock full of impregnable arguments and unsupported assertions, and is organized in ways that escape our understanding. The Court of Appeals is displeased. McCurry's brief seeks review of a variety of interlocutory orders without specifying why they're deficient. The orders include the amended complaint, multiple waivers of service, and routine protective orders. The brief accuses defendant of criminal obstruction of justice, and in a footnote asserts that defendant's schemes were furthered by the U.S. mail. The brief invokes res judicata, collateral estoppel, and judicial estoppel, none of which apply. Ouch. None of which were asserted below, and all of which are therefore waived. The brief includes a section entitled Gamemanship, which contains the following assertion. Defendants have been gaming the system. There is nothing else in this section. The lawyer in me feels like they need to show their work just a little bit more. The brief contains many sentences like this one. Let's bear in mind that everything I'm about to say is one sentence. McCurry experiences a change in fringe benefits, harsher scrutiny, failure to be promoted, lack of opportunities, lack of professional standing, economic sanctions, hostile work environment that led to an employee being shot on premises, various verbal and physical assaults of African Americans by Caucasian employees of the use of gun violence, vehicular assault, amongst other forms of violence, the ever-looming threat that racially motivated altercation or riot may ensue, and physical damage to McCurry's auto, amongst other activities in the conduct. This is a candy-making plant, right? What's going on at this place, according to McCurry? And it's like, what is going on here, man? Jeez. I heard about the Candyman Cam, but man, oh Lord, this is a little bit much. Jeez. There is more, but the point is made. Bad writing does not normally warrant sanctions, but we draw the line at gibberish. I feel that one. I really do. It's like the next thing I write, it's going to be just that much better. I'm telling you right now. It's like I've had the fear of God put in me a little bit. It's like I'm sorry in advance for anything I ever did. Hoffman's filings fall far below the reasonable standards of practice. We therefore order him to show cause within 14 days why he should not be sanctioned or otherwise disciplined under Rule 28 and 38 of the Federal Rules of Appellate Procedure. We also direct the clerk of this court to send a copy of the opinion to the Illinois Attorney Registration and Disciplinary Commission for any action it deems appropriate. Affirmed orders show cause issued. So that is the end of the story of Edith McCurry and Kenco Logistics Services. So in this case, we learned several things. First, the Federal Rules of Civil Procedure can and often are amended by the courts, often by the specific court that you're in. Individual judges have specific rules. So when you're filing a lawsuit, it pays attention. You must pay attention to the local decisions. They're available on the website of the local court. They're not very hard to find, but make sure that you look at the local rules and make sure you're in compliance with those. And then once you're assigned a particular judge, make sure any further filings are in compliance with any specific rules that they have. Particular judges like things in particular ways, and they are masters of their court, so you have to make sure to put things in the specific order. And if you don't do things, among other things, they will be mad at you. And if it goes really bad, they will sanction you. So don't do that. Make sure to look not only at the Federal Rules of Civil Procedure, but the court that you're in, and once you're assigned a judge, any judge-specific rules. That's the first lesson. Second lesson is you can't file frivolous things. If you file frivolous things, you may get sanctioned by the court. So don't make frivolous arguments. And, also make sure that they're not complete gibberish would be a test here. So this is the end of the case of Edith McCurry and Kenco Logistics. I feel for the attorney in this case. I suspect it is not going to go well. I don't know that his local bar committee may necessarily do anything, but the Court of Appeals is going to have just a little bit of fun with him before he's dismissed. I would expect they're going to issue monetary sanctions against him to get the lesson across, and he might get a reprimand from his local bar association, but, not a good time if you're this attorney. So my suggestion to the attorney would be, to fall prostrate before the court and hope for the best. And that is the end of this case.